My name is Audrey Calder. I am 29 years old, and 2 weeks before my 30th birthday, my sister stood in a Cook County courtroom and tried to convince a judge that I was too mentally ill to control my own money. She spoke softly, like a frightened older sister who had spent years protecting me from myself. She said I could not keep a steady job, that I imagined people were stealing from me, and that giving me access to $3.2 million would place me in serious danger. My mother sat beside her, crying into a tissue and nodding after every accusation. She told the court that I had changed after my father died and that my sister was the only person responsible enough to manage my inheritance. I did not interrupt them. I did not raise my voice or defend myself, even when their attorney described me as paranoid, unstable, and financially reckless. Across the aisle, my sister rested one hand on the folder containing her guardianship petition. She looked at me with the calm confidence of someone who believed the money was already hers. What she did not know was that a sealed file had been delivered to the judge that morning. It contained records she had never seen, documents she thought no longer existed, and one fact about my life that my family had mocked for years without ever bothering to verify. The judge read several pages, removed his glasses, and stared directly at my sister. Then he asked, "Do you actually know who your sister is?" My mother stopped crying. My sister opened her mouth, but no words came out. "Before I tell you what happened next, tell me where you are listening from and what the weather is like there. I want to know how far this story of betrayal, patience, and justice has traveled." To understand why my own family wanted a judge to believe I was incapable of managing money, you have to understand what was waiting for me on my 30th birthday. My father, Warren Calder, had built Calder Medical Logistics from a rented warehouse into one of the most respected medical supply companies in the Chicago suburbs. He was not flashy. He drove the same dark blue sedan for 12 years, packed his own lunch, and could remember the names of warehouse employees he had not seen in months. My older sister, Mallory, was nothing like him. She loved expensive restaurants, private investor dinners, and the feeling of being the most important person in every room. After business school, she moved to Orange County and launched Marrow Bay Ventures, an investment fund focused on wellness technology companies. Our mother, Judith, treated every glossy magazine article about Mallory like proof that one daughter had inherited our father's ambition, while the other had inherited his habit of hiding behind spreadsheets. That other daughter was me. I worked remotely for a risk advisory firm in downtown Chicago, analyzing payment records and digital accounting systems for companies that suspected fraud. Because my contracts required confidentiality, I rarely discussed the details. Mallory described my career as freelance bookkeeping and told relatives I spent my days inventing problems inside other people's invoices. I let her believe that because correcting her had never changed anything. 4 years before the court hearing, my father died from a massive stroke while attending a supplier conference in Milwaukee. There was no mystery surrounding his death, no secret confession, and no dramatic final warning. What he did leave behind was a carefully prepared trust. Mallory received control of the operating company, while I was named beneficiary of a separate trust funded by life insurance and the sale of several personal investments. The trust was worth approximately $3.2 million and would be distributed when I turned 30. My father had explained his reasoning in a letter. Mallory had already received opportunities through the company. He wanted me to have the freedom to build something of my own. Mallory called the arrangement unfair, but she could not challenge it without admitting that she had already received far more than I had. For several years, nothing happened. Then Mallory returned from California and took over as Chief Financial Officer of Calder Medical Logistics. She told everyone Marrow Bay Ventures was expanding into the Midwest, but the truth was that several of her investments had failed. 2 health tracking startups had collapsed, a luxury recovery retreat had defaulted on its loans, Investors who once praised her instincts were demanding their money back. Instead of admitting defeat, Mallory began moving money through 3 consulting companies registered in California. The companies submitted invoices to Calder Medical Logistics for strategy, vendor development, and market analysis. In reality, they provided almost nothing. Money left our father's business, passed through those companies, and flowed back into accounts connected to Marrow Bay Ventures. By the time the company prepared for its annual audit, the gap was close to $1.8 million. Mallory needed cash before the auditors examined the vendor files. My trust was the easiest source she could see. 9 months before my birthday, the bank administering the trust received an amendment that appeared to give Mallory authority to advise how my inheritance should be managed if I became mentally incapable. The bank refused to accept it. The signature looked copied. The dates did not match their records, and there was no certificate from the electronic signing platform named in the document. Instead of withdrawing, Mallory changed strategies. She began asking questions about my health. Had I seen a therapist after Dad died? Was I still taking medication for anxiety? Why had I changed consulting assignments twice in 1 year? Did I ever feel that people were watching me? At first, I thought she was trying to repair our relationship. Our mother joined those conversations and encouraged me to be honest. I told them I had experienced panic attacks after Dad's death. I told them therapy had helped. I admitted that working in fraud investigations sometimes made me suspicious of patterns other people ignored. Every honest answer became a sentence they could later remove from context. Mallory told relatives I was obsessed with hidden crimes. She told family friends I could not hold a job. She described my quiet apartment in Northbrook as evidence that I was isolating myself. Our mother supported her because Mallory paid the property taxes, insurance, and maintenance on the large house where she lived. If Mallory lost the company, our mother believed she would lose everything too. I still did not understand how far they were willing to go until 6 weeks before my birthday, when a process server handed me a petition asking the court to declare me disabled and appoint my sister as guardian of my estate. They had not been checking on my health. They had been collecting material for a case. The petition arrived at 8:15 on a Monday morning, 10 minutes before I was supposed to lead a video meeting with a hospital network in Ohio. It described me as unemployed, emotionally unstable, financially reckless, and consumed by delusions about family members stealing money. Attached to it was a psychological report written by Dr. Adrian Cole. I had met him once through a video call that my mother described as a family wellness consultation. The session lasted 52 minutes. He asked almost nothing about my income, my bills, my work responsibilities, or the fact that I had lived independently for 11 years. Instead, he kept asking why I distrusted Mallory and whether I believed she was hiding financial information. At the time, I assumed he was helping us communicate. In his report, he described my answers as possible persistent delusional thinking and suggested that receiving a large inheritance could place me at risk of exploitation or impulsive behavior. The court did not immediately give Mallory control over my money. It did, however, issue a temporary order preventing the trust company from releasing the $3.2 million until the hearing was complete. My salary account remained open, but the damage began almost immediately. Mallory sent copies of the petition to 2 relatives, who forwarded it to other people. Someone contacted one of my clients and claimed I was under investigation for mental incompetence. The client suspended my contract while its legal department reviewed the situation. I had enough savings to survive, but legal fees, expert costs, and lost income could drain those savings quickly. I moved temporarily into the guest room of my closest friend in Naperville because Mallory had started appearing outside my apartment without warning. She would knock, wait for me to refuse entry, and then text our mother that I was shutting out the family. Every reaction was designed to become evidence. That was when I hired Naomi Feld. Naomi specialized in contested trusts, fiduciary abuse, and adult guardianship cases. We had met years earlier when my firm assisted her client in a corporate embezzlement dispute. She did not promise me an easy victory. She placed the petition on her desk and told me Mallory had constructed a powerful emotional story. A grieving younger sister had become suspicious and isolated. A concerned older sister wanted to protect her. A frightened mother agreed. A doctor supported them. Naomi said we could not defeat that story by becoming more emotional than they were. We had to replace it with verifiable facts. First, we examined the trust amendment. A digital forensics specialist extracted the document metadata and found that the file had been created 3 months after my father's death. The listed author was not his estate attorney. It was a user account connected to Mallory's former California office. An earlier version of the file carried the name Audrey Control Draft. The signature image matched a signature from a vendor agreement my father had signed years earlier. It had been copied, resized, and placed into the amendment. The document also claimed it had been completed through an electronic signature service, but the service had no audit certificate or transaction record connected to it. Second, we traced the money. Naomi subpoenaed records related to the companies that had invoiced Calder Medical Logistics. 3 different consulting businesses used the same private mailbox in Irvine. Their phone numbers forwarded to the same answering service. Payments moved from our family company to those businesses, then into an account controlled by Marrow Bay Ventures. The transfers were often split into amounts just below internal review thresholds. Together, they created the $1.8 million shortage Mallory was trying to hide. Third, we examined Dr. Cole's report. The invoice for his evaluation had not been paid by our mother, as Mallory claimed. It had been paid by one of the California consulting companies. The file properties showed that the first draft of his report was created before he interviewed me. An email from Mallory's assistant asked him to include the phrase, persistent delusional thinking, because it would support emergency financial protection. He had reached his conclusion before asking me a single question. The most important witness was Leon Park, the former controller of Calder Medical Logistics. Leon had worked beside my father for 17 years. He had noticed the consulting invoices and asked Mallory to provide contracts proving the services were real. She accused him of resisting modernization and terminated him 2 weeks later. He had saved copies of the approval logs because he believed the invoices would eventually become part of an audit. Those logs showed that Mallory had personally approved every suspicious payment. Leon agreed to testify, but he warned me that Mallory would attack his credibility and claim he was a bitter former employee. Naomi told him that was expected. Then my mother made a mistake Mallory could not explain away. She called me late one evening while I was still staying in Naperville. I did not answer because Naomi had instructed me to keep communication in writing. My mother left a voicemail. She begged me to stop fighting the guardianship. She said Mallory only needed temporary control of the trust until the audit was over. She said if I refused, the company could collapse and the house could be taken. Then she whispered that once the missing money was replaced, everything could return to normal. I listened to the message 3 times. Until that moment, I had wanted to believe my mother was only repeating lies she did not understand. The voicemail proved she knew the guardianship was about the money. What I still did not know was whether Mallory had told her the entire truth, or only enough to make her afraid. By the morning of the hearing, Mallory had transformed herself into the image of a patient and exhausted older sister. She wore a conservative navy dress, no visible jewelry except our father's old watch, and almost no makeup. She sat close to our mother and kept one hand over hers whenever the courtroom became quiet. Her attorney, Ethan Rowe, opened by saying the case was not about punishment, money, or family conflict. He said it was about protection. He described me as a talented but troubled woman whose condition had worsened after our father's death. According to him, I had become unable to distinguish professional concerns from personal suspicion. I moved between jobs, withdrew from friends, accused my sister of fraud, and refused help from people who loved me. He never mentioned that my jobs were confidential consulting assignments. He never mentioned that I paid my own rent, taxes, insurance, and student loans. He never mentioned that the financial irregularities I reported were supported by bank records. Mallory testified first. Her voice trembled at exactly the right moments. She said she did not want my inheritance and would gladly place it under professional management. She claimed the guardianship was necessary because I had become vulnerable to scammers and imaginary threats. When Naomi asked whether Mallory had attempted to submit a trust amendment naming herself as financial advisor, Mallory said she believed our father had prepared it before his death. When Naomi asked who had sent the file to the bank, Mallory said an assistant handled estate correspondence. She could not remember which assistant. Our mother testified next. Judith cried before Ethan finished his first question. She told the judge I had changed after Dad died. She said I stopped attending family dinners and became obsessed with the idea that Mallory was stealing. That part was technically true. I had stopped attending dinners after Mallory began asking detailed questions about my therapy sessions and trust distribution date. My mother said Mallory had kept the family together, supported her financially, and tried everything to help me. She described signing the affidavit as the hardest decision of her life. Naomi asked if I had ever missed a mortgage payment. I did not have a mortgage. She asked if I had ever been evicted, declared bankruptcy, lost money gambling, or transferred funds to strangers. The answer to every question was no. Then Naomi asked whether our mother depended on Mallory to pay the expenses on her house. Ethan objected, but the judge allowed the question. My mother admitted that she did. Dr. Cole followed. He spoke confidently about anxiety, fixed beliefs, impaired judgment, and the risk created by sudden wealth. He referred to my suspicion that Mallory had moved company money as evidence that I interpreted ordinary events as personal threats. Naomi asked how long he had evaluated me. 52 minutes. She asked whether he reviewed my bank statements. No. Tax returns. No. Employment records. No. Medical history from my treating therapist. No. She asked whether he had spoken to anyone at my company. He said confidentiality prevented him, though he had never requested my permission. She asked whether he knew I managed complex financial investigations for corporate clients. He said he had been told I performed occasional bookkeeping work. Naomi allowed that answer to remain in the air. The court-appointed evaluator then presented her report. She had visited my apartment, reviewed my monthly expenses, spoken with my employer, and tested my understanding of the trust. She found no evidence that I was unable to manage money or make personal decisions. She noted that I was anxious about the case, but said anxiety during litigation was not proof of disability. Mallory's expression tightened, but Ethan argued the evaluator had not addressed my alleged delusions about the family company. He said the court still needed to consider the possibility that my intelligence allowed me to hide a serious condition. For a few minutes, it seemed as though the case might become a battle between competing experts. Then Mallory leaned toward our mother and wrote something on a yellow legal pad. I could see the words, Marrow Bay and transfer schedule. She was already planning what to do with the trust. Naomi saw it too. She closed her folder without asking another question. The judge requested the sealed materials delivered by my employer and the trust company. A clerk carried the file to the bench. Mallory watched with mild curiosity. Ethan looked confused because he had received only a summary under the protective order. The judge read silently for nearly 3 minutes. No one moved. Then she removed her glasses and looked directly at my sister. Mallory straightened, expecting to be asked whether she was prepared to serve as guardian. Instead, the judge asked the question that shattered the entire identity my family had created for me. Part 5. Ms. Calder, the judge said, do you actually know who your sister is? Or what she does for a living? Mallory gave a small, uncertain laugh. She said I worked irregular online jobs and had exaggerated my responsibilities for years. The judge asked me to stand and state my full name, age, employer, and occupation for the record. I rose slowly. My name is Audrey Calder. I am 29 years old. I am a lead fraud data analyst for Whitmore Risk Advisory in Chicago, and I am a certified fraud examiner. Mallory stared at me as if I had begun speaking another language. I explained that my work involved tracing fraudulent payments, reconstructing altered accounting records, identifying shell vendors, and preparing reports for attorneys, insurers, and regulatory agencies. I had worked continuously for the same firm for 5 years. The changes Mallory called job instability were separate client assignments. My income had increased every year. I had never been fired, disciplined, or found incapable of handling confidential financial information. The sealed file contained my employment verification, tax records, performance reviews, and a declaration from my managing director. It also confirmed that I had been assisting outside counsel in a confidential financial investigation involving a network of vendor payments. I was not a federal agent. I had no badge, no secret government identity, and no dramatic undercover assignment. I was simply very good at finding where money had gone after someone tried to hide it. The judge looked at Mallory and said the person she had described as financially incompetent was professionally responsible for analyzing transactions worth hundreds of millions of dollars. Mallory recovered quickly. She said intelligence did not prevent mental illness and accused me of using my job to feed obsessive suspicions. The judge agreed that a successful career alone did not settle the case. Then she opened a second folder. She held up the trust amendment Mallory had submitted to the bank. If your sister invented the problem, the judge asked, why does this document bearing your father's signature have a creation date 3 months after his death? Ethan Rowe turned toward Mallory so sharply that his chair scraped the floor. He told her not to answer until they had spoken privately. Our mother stopped crying. Her face lost all color. Mallory claimed she had never seen the metadata and that an estate assistant had prepared the file. The judge asked for the assistant's name. Mallory could not provide one. The judge then asked why an earlier version of the document had been saved under the title Audrey Control Draft on an account linked to Mallory's California office. For the first time that day, Mallory had no story ready. Ethan requested a recess. The judge granted 15 minutes but ordered every party to remain on the floor. In the hallway, Ethan pulled Mallory away from our mother and spoke to her in a low, furious voice. Judith looked at me as if she were seeing a stranger. She asked why I had never told her what I really did. I told her she had never asked. She had accepted Mallory's version because it was useful. Naomi stepped beside me and warned that the trust document was only the beginning. Proving it was false would defeat the guardianship. Proving why Mallory created it would expose everything else. When the courtroom doors reopened, Mallory's confidence was gone, but the evidence waiting inside was much worse than she understood. Naomi began with the digital forensics specialist. He explained how every electronic file carries information about when it was created, who edited it, and what software was used. The trust amendment had been created 96 days after my father's death. The author field matched a user account assigned to Mallory. The signature image had been copied from an old vendor contract and inserted into the document. The file had been edited repeatedly from an internet address associated with her former Newport Beach office. Mallory's attorney tried to suggest that another employee could have used her account. The specialist produced a device log showing that the final version had been approved from Mallory's personal laptop using biometric authentication. Mallory whispered something to Ethan. He did not look at her. Leon Park testified next. He described his 17 years as controller of Calder Medical Logistics and his responsibility for reviewing large vendor payments. He said the 3 California consulting firms had no project files, no work products, and no employees he could identify. When he questioned the invoices, Mallory instructed him to approve them as executive expenses. He refused. 2 weeks later, she fired him. Leon presented approval logs showing that Mallory personally authorized every transfer. He also produced an email in which she wrote that Audrey's trust would fix the gap before the annual review. Ethan argued that the phrase could refer to a legitimate investment opportunity. Leon replied that company money could not legally be replaced with a private beneficiary's trust unless that beneficiary voluntarily invested it. I had never agreed to invest $1. Naomi then displayed a timeline of the transfers. Money left Calder Medical Logistics, entered the consulting companies, and returned to Marrow Bay Ventures. Some of it paid investor withdrawals. Some covered a lease on Mallory's California residence. Some paid for a luxury vehicle registered through one of the shell companies. The total was $1.8 million. Mallory claimed the transfers were temporary intercompany loans. There were no loan agreements, repayment schedules, board approvals, or disclosures to the company's minority shareholders. Next came Dr. Cole. Naomi showed him the invoice for his evaluation. He confirmed that his standard fee for a single psychological assessment was far lower than $18,000. The payment had come from West Alder Consulting, one of the same California entities in Leon's records. Dr. Cole said he did not know who controlled the company. Naomi displayed an email from Mallory's assistant thanking him for helping protect the family assets. Attached to that email was a draft report created 2 days before he interviewed me. The draft already contained the phrase, persistent delusional thinking. Naomi asked how he had reached a diagnostic conclusion before speaking with me. He said the draft was only a template. She asked why the template included my name, my father's death, my inheritance amount, and an accusation that I imagined financial fraud. His answers became slower. The judge asked whether he had disclosed the payment arrangement to me or to the court-appointed evaluator. He admitted he had not. When Naomi asked whether Mallory had requested a conclusion supporting guardianship, Ethan objected, but Dr. Cole answered before the judge ruled. He said Mallory had told him the family needed decisive language because I was about to gain access to dangerous wealth. The judge ended the questioning and ordered that the transcript and documents be forwarded to the appropriate professional licensing authority. My mother was recalled to the stand. Naomi played the voicemail Judith had left me. Her own voice filled the courtroom, pleading with me to stop resisting because Mallory needed temporary access to the trust until the audit passed. When the recording ended, Judith covered her mouth. Naomi asked what missing money she had referred to. Judith said Mallory told her the company had a short-term cash problem. Naomi asked whether she knew the affidavit she signed claimed I could not pay bills or understand financial documents. Judith admitted she knew I had always handled my own expenses. She said Mallory warned that without the trust money, the business would fail and the bank could take the house. Naomi asked the question I had been dreading. Did you believe your daughter's freedom should be traded for your house? Judith began to cry again, but this time the tears did not help her. She said she thought the guardianship would last only a few months. She thought I would eventually forgive them. I realized then that my mother had not been completely deceived. Mallory had manipulated her fear, but Judith had still chosen comfort over me. Judge Miriam Kessler took a brief recess to review the evidence. When she returned, she ruled from the bench. The petitioners had failed to prove by clear and convincing evidence that I lacked the capacity to manage my estate. In fact, the evidence showed the petition itself had been used as part of an effort to obtain control over my trust. She dismissed the guardianship petition, terminated the temporary restriction on distribution, and ordered the trust company to preserve all related records. She referred the suspected forgery, false affidavits, and financial transactions to state and federal authorities. Ethan Rowe asked permission to withdraw as Mallory's attorney, stating that information presented in court had created an ethical conflict. Mallory stood and shouted that everyone was twisting ordinary business decisions into crimes. The judge ordered her to sit down. She refused until a deputy stepped closer. Outside the courtroom, 2 federal agents and an assistant United States attorney were waiting. The criminal investigation into the California vendor network had been developing separately for months. My analysis had helped outside counsel identify the pattern, but Mallory's forged trust document and sworn testimony had provided additional evidence of intent. A federal indictment had been unsealed during the recess. The agents arrested her on charges connected to wire fraud, falsified records, and unlawful diversion of company funds. Our mother remained against the wall, holding the court papers with both hands. Mallory looked at me while an agent secured the handcuffs. "You destroyed everything Dad built," she shouted. I shook my head. "No. You gambled it away, and then you tried to erase me so no one would see what you had done." She demanded that our mother call someone, fix something, or tell the agents they were making a mistake. Judith did not move. Mallory had spent nearly a year trying to prove I could not be trusted with money. By the end of that day, she was the one being forced to explain where every missing dollar had gone. The criminal case lasted 18 months. Mallory fought the charges at first, insisting the transfers were business loans and the trust amendment had been prepared by an unknown employee. That defense collapsed when prosecutors recovered deleted messages from her personal laptop. In one conversation, she told her assistant that once the court gave her control, she could move the trust money into a family preservation account and repay everything before anyone asked questions. In another, she called my anxiety history the cleanest route to control. Facing overwhelming evidence, she accepted a plea agreement. She received 9 years in federal prison and was ordered to pay restitution to Calder Medical Logistics, its minority shareholders, and several investors who had been misled about Marrow Bay Ventures. Her California property, investment accounts, and luxury vehicle were sold or seized. She was barred from serving as a financial officer or raising money from investors after her release. For Mallory, the worst punishment was not losing the expensive life she had built. It was losing control of the story. The public record showed that the sister she called unstable had identified the fraud correctly, while the successful executive had forged documents and weaponized the court system to hide her losses. My mother was not treated as an innocent bystander. She admitted signing statements she knew were false and helping Mallory pressure me into surrendering control of the trust. Because she cooperated with investigators and had not personally received the stolen business funds, she avoided prison. She received 6 months of home confinement, 3 years of probation, and a restitution obligation. She had to sell the Northbrook house because she could no longer afford it. For months, she mailed letters to me through Naomi's office. Some were apologies. Others explained how frightened she had been of losing the company, the house, and the life she knew. I eventually answered one. I told her fear could explain a choice, but it could not erase the harm caused by that choice. I was not ready to rebuild our relationship, and I would not accept guilt as a substitute for accountability. We began exchanging occasional letters, but I kept firm boundaries. Forgiveness, I learned, does not require giving someone immediate access to your life again. Dr. Cole faced a professional investigation. His license was suspended, and he entered a civil settlement related to the misleading evaluation. Part of that settlement funded legal services for people whose mental health history had been misused in family financial disputes. That mattered to me because I never wanted my story to suggest that anxiety, depression, therapy, or medication made someone weak or unreliable. I had experienced panic attacks. I had needed help. Neither fact made me incapable of managing my life. Mental health treatment should protect a person's dignity, not become a weapon used to remove their rights. When the trust was finally released, the full amount was slightly more than $3.2 million because of investment growth. I did not resign from my job, buy a mansion, or spend the money to prove I had won. I hired an independent fiduciary advisor with no connection to my family. I created a long-term financial plan, paid my legal expenses, and invested most of the remaining funds conservatively. Then, I used part of the inheritance to establish the Calder Financial Autonomy Project. The program partnered with community centers and legal aid organizations to help people recognize financial abuse inside families. We taught participants how to keep secure copies of wills, trusts, beneficiary forms, and powers of attorney. We explained why no one should sign an affidavit or financial document under emotional pressure. We showed them how to review account alerts, preserve emails, request professional advice, and choose lawyers, doctors, and accountants without hidden conflicts of interest. We also reminded people that intuition can be an important warning, but serious accusations must be supported by records, qualified experts, and lawful evidence. The goal was not to make everyone suspicious of relatives. It was to help people understand that love without accountability can become control. My work changed too. I remained a fraud analyst, but I stopped accepting every difficult case just to prove I could handle it. I traveled more, spent time with friends who respected my boundaries, and learned to build a family from trust rather than biology alone. At the first workshop funded by the program, I watched an elderly woman place copies of her estate documents into a secure folder. A young man asked how to protect a parent from a relative pressuring them to change beneficiaries. Another woman quietly admitted that her brother had been using her depression diagnosis to control her bank account. I realized then that my inheritance was not the greatest thing I recovered. I recovered the right to define myself. The most important lesson from my story is that no one should be allowed to turn a mental health struggle into proof that you do not deserve independence. Keep records. Ask questions. Seek professionals who have no financial interest in the outcome. Never let shame stop you from requesting help. And remember that standing up for the truth is not the same as destroying a family. Sometimes the family was already being destroyed by secrecy, greed, and fear. Telling the truth simply makes the damage visible. What would you have done if the people trying to take away your freedom were the same people claiming they wanted to protect you?
Thank you for joining with us for this fictional journey. Everything in this story was created only for dramatic storytelling, entertainment, and reflection. We hope it reminds you that the person who walks away with their dignity intact has already won something far more valuable than a temporary argument.